Okay, Trejo, step over here. Keep in mind they can see you, they can hear you. So let's just have a seat right here and we'll be on standby.
All right, good morning. Who is this?
Josh, this is Mr. Trejo Anthony. He's in El Paso County Jail.
All right.
Good morning, Your Honor. That's my client. Good morning, Judge. How are you?
Good morning. Good. How are you, Edie?
Hey, Judge. How are you?
Good, good. Oh, Mr. Trejo.
Yes, ma'am.
We missing anybody?
They're doing that.
5, 6, 7, 8, 9.
Trejo.
Everybody's here.
All right, are we ready to proceed on Mr. Trejo?
Yes, Your Honor. I was going to ask the court for a 2-week reset. Mr. Trejo was, I've read the notes. I understand that Mr. Stevens left some notes. There was a hearing, a admonishment in December. So he's picked up on the KPS. He got arrested, I believe, on Sunday. Miss Maya Quevedo had an initial interview with him and she had concerns still about his competency. And I said, he's not competent. And my social worker, Miss Raina Kohler, was able to speak with him. I have not, but at this point right now, we do need to find a better place for him to live. OCR won't take him back. And without going into detail, Judge, I think he probably just needs to get a little bit more stable, maybe on some medication in the jail before we're ready to actually get a viable safety plan. So I'd ask the court for 2 weeks.
Okay. I am very familiar with the case and we had been dealing with Brent, but those recent activities of his were very concerning. So I'm not surprised OCR won't take him back. So let's see what we can do to get him stable and get him a better treatment plan.
We'll
So,
do, Your Honor.
2 weeks will do. If you realize you need more time, then let us know.
I will. Thank you, Judge.
Thank you. Good to see you.
We'll check in with you,
Gracias, Edita.
I'm
All
sorry.
right, so we are done with Mr.
Gracias,
Trejo.
Edita. Muchas gracias, Edita. ¿Cómo está, ma'am?
Thank you.
Oh, thank you. Bye-bye.
All right, Josh.
Who else do you have?
No, I was just gonna say, Mr. Trejo, he was the only inmate with the only inmate listed with us at the county jail. If nothing else, and with the court's permission, we're gonna proceed to log off.
All right, thank you very much.
You all have a good one.
Los amo, se portan bien.
Okay, moving right along.
Arlene?
All right, Annex, good morning.
Good morning, Judge.
Who do you have?
We have Arlene Rios.
Arlene Rios, okay.
If you want, Judge, we can go in order of the docket. It's up to you, ma'am.
It doesn't matter to me.
And Judge, this is the interpreter. Is Ms. Rios the one that needs the interpreter, or do you know?
I don't know yet. Let's see. Who needs? Yes. Okay, then let's do Ms. Rios because she needs the interpreter. Let me go on here again.
Judge, I'll call Max Munoz to get on.
Okay, please. Okay, the drop, there it goes.
There was a little thing that's.
Yeah, like a world.
I think they have to initiate it,
Okay.
and then when he comes on, there it is. See?
There you go, yeah. Finish. See.
All right.
He's logging on now, Judge.
Yes, I see him here. All right. Yes, I can. Diane, can you hear her?
Yes, ma'am.
All right. Then, Mr. Munoz, are you with us? Mr. Munoz?
Yes, Your Honor.
There you are. Okie dokie. What do we have on Ms. Rios? It appears that this is the only case that's holding her in.
That is correct, Judge.
So what are we doing on Ms. Rios?
Last time we talked about it, I asked to see if they would dismiss the case, and she's going up for 6 years. I don't know.
Okay, has the state looked at the case?
Last time we
Hi.
talked about it, they were supposed to. I don't know if they have or not.
Your Honor, Linda Perez on behalf of the state. Yes, I actually am familiar with this case, Your Honor. Ms. Crespo, ADA Crespo was the one that brought it to my attention. It was my understanding based on the my communication with Ms. Crespo was that initially Mr. Munoz had indicated that part of the agreement when Ms. Rios pled out of CDC1 that former ADA Gutierrez had agreed to dismiss the pending assault. I did go out of the way to make sure because I was willing to honor that. I reached out to Judge Navarrete. There was no notes indicated on her docket that there was an agreement with regards to the dismissal. I reached out to the court reporter, Ms. Angie Morales. There was no mention of it on the record. And I also reached out to former ADA Gutierrez, and there was never an agreement. I also reviewed the plea documents, and the plea documents were signed by Mr. Rios and Mr. Munoz prior to the assault occurring. The plea documents were signed by Mr. Rios on the 3rd of, Ms. Rios on the 3rd of September. The assault did not occur until October. So at this
That is
time,
correct,
my
Judge.
understanding is it's credit for time served.
That is correct, Judge. This came after. So what I did was I proffered to see if they would dismiss the case. I never said that there was an agreement.
Okay,
I don't know what they want to do. I mean, that's when my thing is that she has already been sentenced to 6 years. I mean, what else do you want?
it appears they are not willing to dismiss it straight out. So,
That's correct, Your Honor. I did review the case. I did review the evidence. There is a video on portal. I understand that, the complaining witness is an inmate or was an inmate at the time. My understanding is she has been released. She is being represented by the public defender's office. There is a co-defendant that is also involved, and the victim did sustain injuries.
okay, so you're not willing to dismiss it at this case?
At this time, no, Your Honor. I believe Ms. Crespo had relayed a recommendation of credit for time served.
All right, Mr. Munoz, do you want to schedule this for a plea or a jury trial?
Your Honor, I have to speak with Ms. Rios again. I have not spoken to her regarding this case since I believe this case came right after or right before she pled, Your Honor. I was not aware about it until afterwards.
Okay,
So I'd like to see what there is, or see if there's any mitigating circumstances.
all right, then I'm going to give you 2 weeks to
Sounds good to me.
look into it, talk to her, and if you don't get back to us before the 2 weeks, we will have a hearing in 2 weeks.
Sounds good. Okay.
All right,
Thank
thank you
Your
very
Honor.
much. Take care.
And you're welcome to reach out to me, Mr. Munoz. I'm willing to listen to any mitigation information you have.
I will. Thank you, Ms.
Thank
Perez.
you. No problem.
All right. Thank you. Do we need the interpreter for anything else?
I believe Mr. Venegas needs an interpreter, Judge.
Okay, can we do Mr. Venegas?
No, I don't believe he does need an interpreter.
No?
He speaks English, yes.
Okay. Mr. Venegas, let's talk to him and see what he wants to do.
Yes. Venegas?
still need her?
Mr. Venegas? Good morning, Mr. Venegas. Do you speak English?
He does have a trach tube, so he might have trouble speaking loud enough to be heard. Because he
Okay.
has to, yeah.
Yeah, I can barely hear you there. Do you want to use an interpreter or do you want to go forward speaking English, sir?
I can speak English.
Okay, then is that the only other one we need? Yes? All right, thank you, Ms. Garza. We appreciate your help. All right, so this is a pre-revo for Mr. Venegas. Have you had a chance to speak with the state, Mr. Moore?
No, I have not, Judge.
What is the state's recommendation? Mr. Venegas has been on probation since November 19 of 2019, that is, for burglary of vehicle, and it looks like he's straight out absconded.
That is correct, Your Honor. Linda Bettis on behalf of the state. The state has filed the motion to adjudicate, Your Honor, that was filed by ADA Nelson on the 5th of January of 2020. There are 3 allegations: failure to report, failure to complete the NCTI class, as well as failure to participate in TAP. At this time, given the fact that he has been on probation for over a year and has failed to comply with the stipulated probationary terms, we are recommending revocation at this time.
And doing what?
I'm sorry, Your Honor?
Doing what on the revocation?
A credit for time served. He's already been in for 89 days. It would be credit for time served.
Okay. I'm not sure why we set this case other than the fact that the defendant is in jail and has been there for quite a while.
I set it up because of the pending motion, Judge, and he's already on probation with that pending felony.
He's
So
also
is he-
being held on a bench warrant from the 168th, Judge.
Okay, that was my question. All right, so now that you're aware of the state's intentions, Mr. Moore, what do you want to do?
Well, I need to, of course, figure out what they want to do in the 168th. They haven't given me a hearing yet. The time served offer sounds like something we might consider, but of course, until I know what the 168th, what's going to happen there, it's difficult to say.
Well, I'm not waiting for the 168th. Mr. Venegas has 89 days in jail on this case. I'd like you to talk to your client, figure out what you want to do, and the next hearing will either be a plea of true or a contested revo.
Judge, I think now I can't commit my client until I speak to him, but I think if you set it for a plea of true, in case that's what he wants to do, I can get the paperwork and we can do it if that's what he chooses.
Okay, that will work. We will get you the paperwork and give you some time to talk to your client. As soon as we get everything back, we'll schedule the plea of true and get this done.
Yes, Judge, thank you.
Thank you.
May I be excused?
Yes, sir. All right, who is next? Did I have anything other than the guy who bonded out? No?
Oh, we'd still be waiting on Danzel Davis, Your Honor.
All right.
Hello.
Mr. Herrera,
Yes.
it appears your client bonded out yesterday, so we don't have a hearing today.
Come on.
You are excused.
Judge, he's also on Denzel Davis.
Oh, okay.
Your Honor, just to clarify, because it's going to be confusing at first glance, he's got one of Mr. Davis's cases and I've got 2 of them.
That's correct.
All right. Can we get the public defender on everything since we need to combine all of these?
Yes, Your Honor, I have no objection at all to that. I would actually appreciate it. I don't know if Mr. Herrera has any strong feelings.
Judge, if I may,
Yes, sir.
I thought we had a deal with the DA that the deal was this, that Mr. Denso would complete anger management class. He would pay back restitution. He's done all that and they would dismiss it. They still haven't dismissed it yet.
That was your case?
Yes, the criminal mischief.
Okay.
So I'm just waiting for a dismissal on that.
All right.
If I may, Your Honor, Mr. Herrera, did you provide proof of that? Let me check the.
Yes, I did.
Okay.
It was with Lisa
Lawson?
Lawson, yeah.
Oh, that was since last year?
Yes.
Okay.
So you have the completion of the class and the receipt showing that the restitution has been paid.
Okay. Let me just double check on the notes on that.
All right. If need be, I can send them back to you. I can email them back to you again.
I'm just making sure that it
Yeah.
is the agreement that was reached.
Oh, okay. And you do have the proofs.
My understanding is that she did not agree to dismiss it until everything, the discharge was also disposed of, which is why that dismissal has not been submitted.
Okay. You do have the restitution receipt showing it's been paid and the completion of that anger management.
Right, but the agreement was also that we had to dispose of the case that the public defender is also
Okay.
representing him on. So not
Okay.
until all the cases are resolved will we dispose of the criminal mischief.
Okay. Yeah, no, I wasn't aware of that because it wasn't my understanding. That's why we complied and we're waiting for it. I don't know what else he can do. The other cases are not resolved, and I'm not sure they're not going to be resolved anytime soon. So,
Your Honor, very quickly, if it's true that he's already got everything on his end set up, I don't know if we even need to transfer this over to the public defender's office. If
Right.
his disposal is waiting on mine, I'll just handle mine, and he's just kind of piggybacked. Do you
Right.
guys think it works?
That's fine with the state.
Okay.
We'll just leave everything as is, but we do need, Ms. Bettis, would you talk to someone and see if you can get that dismissal done since he has complied with the agreement on the criminal mischief and you still have the other two cases to work on? Because that could be quite some time if they're set
Correct.
for trial.
Correct, Your Honor. So at this time, what I would propose, let me go ahead and review that. I would not specifically just to that particular case on the criminal mischief, not oppose a PR bond, but I would oppose, of course, once we start the bond hearing, a bond on the discharge and the assault.
Okay, well, we're going to address those now. Mr. Reddit, are you in agreement to a PR bond on the criminal mischief?
Judge, if I understand you correctly, I think I'm done with my end of it. If the only reason it's not being dismissed now is because they want the other charges disposed of together.
Well, you're
then-
not done because he's back in jail on everything.
Okay.
So my question again is, are you in agreement with a PR bond on the criminal mischief?
Yes.
Okay, then you are excused. I will do a PR bond on the criminal mischief. And then you're done and we'll just wait for your dismissal.
Okay.
All right?
And my next case.
Well, no, the other case bonded out.
No, I'm talking about, I have another case, an Abraham Nunez.
Yes, he bonded out. You're
Oh, he
done
did?
with that case. Yes,
Okay, so we're done.
we are done.
All
Thank you.
right, this is my lucky day. Judge,
All
thank
right.
you.
So let's take up the bond hearing on Mr. Davis on the other two cases. Mr. Dowd,
Yes, Your Honor.
are you ready to proceed on a bond hearing for Mr. Davis on the other two cases?
Yes, ma'am.
All right, then let me go ahead and call them. Court calls the cases of the state of Texas versus Denzel Jermaine Davis, cause numbers 2020-C03915, 2020-C10504, and 2020-C06567. Let the record reflect, this proceeding is being heard under the various bond or orders issued by the Texas Supreme Court and the Court of Criminal Appeals regarding coronavirus, the guidance issued by OCA, and the El Paso Council of Judges statement to the attorneys of the bar regarding coronavirus. May I have announcement of counsel?
Linda Bettis for the state of Texas, Your Honor, ready?
Joseph Dowd for the defense, Your Honors. Defense is ready.
All right, what do you have, sir?
Well, Your Honor, the primary thing I want to talk about here is that he's already been in jail for 26 days. And as you're aware under statute, if the state's not ready for the trial within 30 days, he's got to have his bond reduced or be released on PR. That's the first thing. The second thing is as regards the assault family violence allegations, which are usually where whenever we're having these bond hearings, we get into the tricky situation of where he's going to go and he needs to not talk to him. The complaining witness has already agreed to sign a non-prosecution statement in that case. And I believe that until that's done, he does have another place he can stay. And he'll tell you about that in a second when you ask him where he's going to go and all that. So there's not going to be any issues there with him reoffending in that manner. The second thing is you'll see that he's got a discharge of a firearm, Your Honor, just so you know what the facts are in this case. You don't think he's a madman just running through the streets or something. Another person in that case brought the firearm with him and started an altercation. During that altercation, the firearm was brought out and struggled over, and that's what led to the firearm going off. So there shouldn't be any real anticipation here of a public danger. It's not like he's got a bunch of guns he's carrying around and shooting off in a public place. He got into a fight with somebody that had a gun. So those are just the facts that I think are most important for you to be aware of, Your Honor.
All right. Well, my concern is that while he's out on bond on two cases, he picks up a third case. Does the state have anything?
Yes, Your Honor, the state is opposed to a straight PR bond. With regards, we also express the same concerns as Your Honor does. For the record, Your Honor, Mr. Davis is a convicted felon. He was convicted of a UUNV, unauthorized use of a motor vehicle, which is a state jail felony. He was sentenced to 180 days. He also was placed on deferred on an engaged in organized crime, which also involved an assault. He also has a conviction. It was indicted as a robbery, but was reduced to a misdemeanor. He also has a possession of a controlled substance. Your Honor, our concern here is obviously based on his criminal history, specifically the engaged in organized crime, which did involve an assault. And here we are again, while he is on PR bond. The initial charge with a discharge of firearm that occurred on the 7th of May of 2000. The court did grant him a $2,500 PR bond. A few months later, he reoffends on that criminal mischief. At that time, again, he was granted a $2,000 PR bond. I do understand that he has satisfied the conditions that the state offered at that time. Knowing that he still has the pending discharge of a firearm and that criminal mischief, he decides to reoffend again. This one, not only did it occur, it was specifically on Christmas Day on the 25th of December. The allegations, Your Honor, is that Mr. Davis apparently became upset, punched his girlfriend twice, causing her to fall, one in the chest and the other in the stomach. Apparently, he was upset because there was some argument. He took the the girlfriend's phone away along with $400, and then he left the scene. At this time, Your Honor, based on the fact that he does have an extensive criminal history, specifically of a prior assault, and the fact that this court has given him 2 opportunities, and obviously Mr. Davis does not grasp the severity of him reoffending, we are opposed to a straight PR bond.
Your Honor, if I could very briefly be heard.
Go ahead.
I would just like to call to the court's attention, we didn't get a response on the main thrust of my ask here, which is that if we don't do this now, in 4 days, he's got to get released on a PR bond anyway. Because the statute says within, I mean, unless the prosecution can tell me with a straight face that they're ready to go to trial on both of these in 3 days, then under the statute, release because of delay, it's within 30 days from the commencement of his detention if he is accused of a misdemeanor punishable by a sentence of imprisonment in jail for more than 180 days. That's the maximum we can keep him in jail for bond because he can't pay. That's the maximum. We're at 26 or 28 days, depending on how you count it. So unless we want to be here in 5 days, I'm asking for him to get his release on PR bond now.
Well, there's no proof that the public defender's office has provided as to why he cannot pay a bond in this matter. No proof has been presented.
So the statute doesn't require proof. It says a defendant who is detained in jail pending trial of an accusation against him must be released either on personal bond or by reducing the amount of bail required if the state is not ready for trial criminal action for which he is being detained. It doesn't say if he doesn't have any money. It doesn't say if he can't.
What statute is that, Mr. Dowd?
Article 17.151, release because of delay, Section 1.
And Your
Right,
Honor, with regards to that, obviously, Mr. Dowd is very well aware of that at this time, due to the current COVID-19 pandemic, we are not allowed to proceed on any matters. If you know the court chooses to, we will be ready to proceed with regards to this matter.
All right. So, Mr. Dowd,
Yes.
first off, I need the name of the complaining witness on the criminal mischief.
Yes,
Can
Your
somebody
Honor.
get me that?
Yes, Your Honor. I'll work on getting that for you right now. You can have that off the top of their head before I start going on the office.
Your Honor, with regards to, I had already had the one on the assault, if the court is wanting that one as well, that is Christy Marie, I believe it's Jenkins, Jenkn.
Okay.
And I will get you the one on the criminal mischief.
Yeah, because we have Christy Junker, and I was making sure that was right because I didn't know if that was a typo in the last name.
The information shows Junker.
Okay. Thank you, Your Honor.
But I do need the other one as well.
Your Honor, on the criminal mischief, it is Adriana M. Adame.
The female can go back, right? You don't need her to sign?
All right. Then on the criminal mischief, it'll be a 2,500 straight PR bond with intensive supervision. On the discharge of a firearm, it's 3,500 PR, 1,000 surety. And on the family violence, it is 2,500 PR and 2,000 surety. With intensive supervision, no contact with Christy Junker, random urine analysis, commit no new offenses, no use of illegal drugs or alcohol, provide current contact information. So.
Thank you very much, Your Honor.
there we
Denzel,
go.
call me once you get out, man, because we need to talk about the conditions of this bond. You got to abide by them, all right, man?
You wind up in jail again, sir. You're going to sit there until all these cases are resolved. And take my word for it, it could be quite a while. All right. So who's next?
Your Honor, that's my last case for the day. With your permission, I'd like to be excused.
Sure. Good to
Thank you
see
very
you.
much.
Take care.
You too.
Do we have Juan Herrera available?
Yes, ma'am.
All right. Mr. Trochet, are you with us?
Here. Yes, Your Honor, I'm here. I apologize.
All right. Let me go ahead and call the case. Court calls the case of State of Texas versus Juan Carlos Herrera, 2020-C03655. Let the record reflect this proceeding being heard in compliance with the emergency orders of the Texas Supreme Court and the Court of Criminal Appeals under various miscellaneous docket numbers regarding the COVID-19 state of disaster, the guidance issued by OCA and the El Paso Council of Judges statement to the attorneys of the bar. May I have announcement of counsel?
Linda Bettis for the state of Texas. Your Honor, we're ready.
Jose Crochet on behalf of Mr. Herrera, we are ready, Your Honor.
All right, you are Juan Carlos Herrera.
Yes, Your Honor.
Raise your right hand, sir. Solemnly swear affirm testimony you may give in this matter be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right. What do you have, Mr. Troche?
Your Honor, Mr. Herrera and I have had several conversations. He's got 1, 2, 3, 4 felony cases, and of course, the case in your court, misdemeanor cases. He at one point asked me to go ahead and get him another lawyer. He was not satisfied with my representation. We have filed motions in all the cases. The felonies have not been set, the withdrawal. So if the court grants the motion, I would ask that perhaps the court might want to wait to see what, who's appointed, and then appoint that lawyer in the felony.
Well, don't worry about the appointment, sir. Just
All right.
what court are the felonies in?
All the felony cases, Your Honor, are in the 346 District Court.
Okay. Mr. Herrera, what seems to be the problem with Mr. Troche's representation?
Well, I was just, it's just the lack of communication due to the fact that I was just assaulted October the 30th, and I've been incarcerated since with broken ribs, eye fracture, and a broken nose, and I still can't heal from my wounds due to the fact I gotta get up, I gotta go, I gotta be getting up for my medication, getting up to eat, and I've been with broken ribs since October the 30th. And that was an understanding that I had with him that, I mean, I found myself kind of frustrated at the time because it's kind of hard to do with broken ribs while you're still incarcerated in here and having to do the steady movements that I'm required to be doing on a daily basis.
Right, but Mr. Troche doesn't have anything to do with whether you're incarcerated or not, sir. It would be the court.
Yes, I'm aware of that, man, but I had also asked them to follow a motion for a bond reduction. So I would be able to be granted something to be able to get out. So at least won't have to be going through the pain that I'm going through while I'm in here. I've been sitting here with the broken wrist as well for over a year. And I'm just in a lot of pain, and it's frustrating for me as a grown man to be in here when I feel like one-legged man in the hand-kicking contest.
Okay, well, with 4 felonies, my guess is, I mean, these guys are lawyers, not magicians. They can't make your cases go away. And if the court looks and you have 4 felonies, it's not very likely they're going to let you out on bond, sir.
I'm aware of that now.
All right.
Your Honor, we
I'm-
did have I apologize, Your Honor. We did have a motions hearing and the court denied him. He was out of bond and he picked up a new case. And then after that, we had a bond hearing and the court denied it. So, and I understand his problem. He was assaulted in jail, but I'm not sure. We have a new judge in that court. I can try again, I guess, so we'll.
All right, well, in light of the circumstances, I'm going to grant the motion to withdraw. This will be the only motion to withdraw you get, Mr. Herrera. If you don't like the attorneys that's appointed, then you're going to have to deal with the matter as it is. I'm going to review the lawyers that are qualified to be on both the felony list and the misdemeanor list and appoint somebody off of there. So you'll need to talk to your new attorney and hopefully the felony court will go ahead and follow the misdemeanor court since they haven't held their hearing, and appoint the same attorney so he can take care of all your cases. Anything further?
Not from us, yeah.
All right. So who else do we have?
May I be excused, Your Honor?
Yes, sir.
Thank you.
Mr. Blake, are you with us? Yes. All right, can we have Mr. Solis, please?
Yes, Judge, I'm here.
All right. Court calls the case of the state of Texas versus Fabian Solis Teruel, cause number 2020-C04499. Let the record reflect this proceeding is being heard in reference to and compliance with the emergency orders of the Texas Supreme Court and the Court of Criminal Appeals under various miscellaneous docket numbers, the guidance issued by OCA, and the El Paso Council of Judges statement to the attorneys of the bar. May I have announcement of counsel?
Linda Pettis for the state of Texas, Your Honor, ready?
Michael Blake from Mr. Solis. We're ready, Your Honor.
All right, you are Fabian Solis?
Yes, ma'am.
Raise your right hand, sir. Solemnly swear or affirm testimony you may give in this matter be the truth, the whole truth, and nothing but the truth, so help you God. Is that a yes?
Yes,
Are you a U.S. citizen?
I'm a resident.
You can put your hand down. Have you discussed the immigration consequences of a plea of guilty on this matter with your attorney?
Yes, Your Honor.
And
you're
Judge,
aware-
Judge, he actually had an attorney, an immigration attorney appointed, and that attorney met with him.
Okay, so knowing all that, sir, you're aware of the consequences and you wish to plead guilty today. Is that correct?
Yes, Your Honor.
All right, charged with the offense of driving while intoxicated, alleged to occur May 26, 2020 in El Paso County, Texas. To those charges, sir, how do you plead, guilty or not guilty? Pardon?
Yes.
All right. Any priors, Ms. Bettis?
Yes, Your Honor, he does have a DWI over 0.15 stemming back to 2012. He also has a possession of marijuana, a wrongful, fictitious, or alteration of vehicle registration, as well as an assault family violence.
All right. Court will follow the state's recommendations, find you guilty, sir, sentence you to 60 days in jail with credit for all time, sir. Anything further?
Nothing further from the state, Your Honor. Thank you.
Mr. Blake, anything further?
No, ma'am, Your Honor.
All right, thank you. Do we
No, ma'am, Your
have,
Honor.
okay. You're
Thank you. Have a
excused,
nice
sir.
day.
Thank you. You too. Do we have Mr. Harris with us? I don't see him on here. Let's see if we can get a hold of him.
Yes, Judge, Mr. Harris is on.
He is?
Yes, ma'am.
Okay, then let's get Mr. Villarreal.
Yes, ma'am. Yeah.
Can I take my mask off?
All right, court calls the cases of the state of Texas versus Benjamin Villarreal, cause numbers 2019-0C05323, 2019-0C05968, and 2020 P file 12715. Let the record reflect this proceeding is being heard in reference to compliance with emergency orders of the Texas Supreme Court and the Court of Criminal Appeals under various miscellaneous docket numbers, the guidance issued by OCA, and the El Paso Council of Judges statement to the attorneys of the El Paso Bar regarding coronavirus. May I have announcement of council?
Chaz doing aye with the state. State is ready.
Robert Harris for the defendant. We're ready, Your Honor.
Okay, so this is one of the CCR 4 cases that were brought over. So we thought we would put it on here and see what the issue is. All right. What do you have, Mr. Harris?
Your Honor, we just, can you hear me?
Yes, sir.
Oh, okay. I'm holding you by hand because it went, we lost our battery power. We got the notice of this hearing yesterday, so I have not really talked to my client about this new case. But he does have 2 pending cases, similar, and we're just asking for a PR bond. He has not been convicted of those cases, so we're asking to release him on a PR bond, and we'll get together with him in the next week or so and go over the case.
All right. My concern is that I was notified that he's been in jail quite a while on these cases.
Well, he'd been out on bond until he got this 3rd case. That's right.
Well, where's my document? It's showing that he's been in jail for 49 days on these cases now. State?
So the state is opposed to a straight PR bond and would request a split bond. Like defense counsel stated, he was out on bond, but then he picked up a new assault family member, and that was actually the son of the complainant from the previous assault. So he went back and assaulted the same family again while out on bond.
Do you know there was a no contact order?
There was a no contact order with the complainant from the first case.
All right.
And so he showed back up at the same residence, got into a verbal argument, and ended up assaulting the son now.
All right. Mr. Harris, was Mr. Villarreal employed?
To be quite honest, Judge, I don't remember right now if he was employed. I believe he was, but I can't
Let's
answer.
swear him in and find out. You are Benjamin Villarreal?
Yes, ma'am.
Raise your right hand. Solemnly swear or affirm testimony you may give in this matter be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
All right, were you employed when you were out on bond?
Yes, ma'am.
Where were you working?
Self-employed. I work as I work on homes.
What do you do?
I get roof, frame, sheetrock, trim, paint, concrete, form, excavate.
All right. What part of the no contact order did you not understand, sir?
I didn't have any type of piece of paper or anything that nobody let me know.
Well, when they let you out on bond, they should have explained the conditions to you.
There wasn't, ma'am.
Okay. On the 2019 assault case, he has a 0 bond, so he should have some kind of bond on that case.
Your Honor, if I may, Linda Bettis on behalf of the state, also an additional concern that we do have is that when Mr. Villarreal was released on the first family violence where the victim is Crystal Martinez, he failed to report since being released. There is a violation notice from the PR department indicating that he has not reported since June of last year.
Yes, I am aware of that as well. So, Mr. Villarreal, if you want to stay out on bond, one, you need to quit getting or picking up new offenses. Two, you need to report to the PR people or they will revoke your bond. And three, you cannot have any contact with the people they tell you not to have contact with. Do you understand that?
Yes, ma'am.
So on the 2019 assault case, I'm going to put a 1,000 surety bond and a 500 PR bond. You are not to have any contact, and by that I mean absolutely none. No phone calls, no going by there, no letters, and you can't have anybody else do these things for you. You are to have no contact with Crystal Martinez. You are to report to PR bonds like they tell you. You're going to have random urine analysis. You're to commit no new offenses. You're not to use any illegal drugs or alcohol. And you are to maintain current information with the Criminal Justice Office. Do you understand that?
Yes, ma'am.
If I hear that you're not reporting or that you picked up a new offense, then you're going to wind up back in jail. And you're not getting out on a PR bond again. Do you understand that?
Understood.
Who is the complaining witness on the P-file case?
The complainant is actually the son. He's a 16-year-old.
What's
He's the
his name?
son, Julian Martinez.
Julian Martinez, okay.
Yes, Your Honor.
Why isn't that a felony if he's a minor?
We will go ahead and review that case, Your Honor, with regards to the potential re-indictment to a felony.
All right, so there is a 2,000 surety bond on that case and a 1,000 PR bond. All right, anything further on that case?
No, Your Honor.
No, Your Honor.
All right, thank you, Mr. Harris.
Thank you, Your Honor.
Thank you, Judge.
And- Pardon?
So what am I looking at now, Ms.?
Your attorney will talk to you about that. Is Mr. Sanchez, Roberto Sanchez with us? There he is. He's in the waiting room. Let's let him in. Let's bring in
I didn't understand.
Kindla or? Good morning, Mr. Sanchez.
Judge, good morning.
Okay.
Hey, he's gonna be all right. Yeah, you're gonna be all right. Okay.
Your Honor, who did you meet next?
Pardon?
Who did you meet next?
I'm not sure how to pronounce their name.
Okay, he says he speaks a little bit of English, more Vietnamese.
Okay,
Let me get it for you.
let's get him here. Have you been able to communicate with him, Mr. Sanchez?
Judge, I really don't know how to answer that question. I've spoken with him. He understands, I think, mostly what I'm saying, Judge. As I was explaining earlier.
You're kind of cutting out on the audio.
I apologize, Judge. I've spoken with him. His English is very, very, very choppy. So I would feel uncomfortable to ever do a plea with him.
Again, you're cutting out. As you move lower, your audio cuts out.
I apologize. Is that better, Judge?
That's perfect there.
Okay, sorry about that. Judge, as I was explaining, I've spoken with him. I think we're getting our messages across. However, I would feel uncomfortable doing a plea with him, Judge.
Well, we're set for a bond hearing today.
Yes, Judge. And the only thing with the bond hearing, Judge, is I think it's kind of moot because he has a blue warrant, Judge.
Oh, okay.
Your Honor, I think on this one, he does have a blue warrant. He has a parole hold. He was sentenced to 3 TDC back on the 1st of March of 2019 out of Porter County, which is Amarillo. I believe he initially was placed on probation for a burglary of HAB in 2018. Subsequently, that was revoked and he was sentenced to 3 TDC. My understanding is his 3 TDC sentence will be completed this year, the 14th of November of 2021.
Okay. So Mr. Sanchez, basically you need to decide whether you're going to plead it or set it for trial.
And I realize, Judge, the only thing though is before I plea it, which I think that's where this is going to go. I need a translator for him, Judge.
Okay. Norma, please, what does he speak?
Judge, he speaks
Burmese?
He speaks Mayar.
Pardon?
He speaks Mayar, Myamr. It's a dialect off of Philippines, Judge.
Okay.
And there lies the problem, Judge.
Okay. I'm not sure if this is a case Norma had spoken to me about. Is this it, Norma?
Yes, yes, Judge.
Okay. Any luck on finding the telephonic interpreters?
Jen helped me yesterday on it. We're supposed to get in touch with an agency that may have an interpreter because the ones that I had been in contact with do not have an interpreter for the language. So
Okay.
I need to follow up with the contact that Chin got for me yesterday.
All right. Then let us follow up on that, Mr. Sanchez, because this is not the ordinary interpreter that we need, I guess, or it's not a language that's used commonly here. They're having a hard time getting an interpreter. But let me see what we can do. And as soon as we have somebody, we'll give you the information so that you can communicate with your client and decide what it is you want to do on this case.
Okay, thank you very much, Judge.
Right? Okay. How do you pronounce your name, sir?
Kyin.
Kent, but is that your last name or first name?
The first name, man.
First name. How do you pronounce your last name?
HLA.
That's how you spell it. How do you pronounce it?
La.
La? Okay. Mr. La, you speak some English?
A little bit, man.
Okay. We are going to reset this matter for a couple of weeks and give my staff time to try to find an interpreter so that you can communicate with your attorney.
Yes, ma'am.
So hopefully we will see you back in a couple of weeks.
Yes, ma'am.
Thank you. All right, Mr. Sanchez, we'll let you know as soon as we get somebody.
Thank you very much, Judge. May I be excused?
Yes, sir.
Thank you, Judge.
Thank you. And now Mr. Lujan.
Yes, ma'am.
why do we have these matters set for an arraignment?
Judge, this is the one that PR Bond had contacted you. He had been sitting in jail, and then they added, he had picked up new offenses, and you said if we hadn't brought him over, to bring him over, I think maybe for a status on the pending stuff.
Okay. So he has quite a bit of stuff.
Yes, Judge, in addition to the felonies also.
All right, so he has a no bond warrant on the felony. Then he's got the evading, the tampering, theft, possession, manufacturing, delivery, another theft, another evading, and then a criminal trespass. What's happening on the felony, Mr. Avelar?
Good morning, Judge. Yes, ma'am. We anticipate a status coming up here either this month or early next month, Judge.
Uh-huh.
To answer the court's question, what is happening is the prosecutors want to send him to prison for a substantially amount of time, Your Honor. In fact, one of the prosecutors is a unit case, and so they're the ones looking closer at his new felony that he picked up, Your Honor. So basically, he's on revocations in the 243rd, and then he's on new felonies in the 243rd as well, Judge. And that's kind of the holdup in this case, Your Honor.
Okay. So he has 3 felonies. Then he has 6 cases with us. But it does us no good to give him PR bonds because he has those felonies.
I suppose I could make my spiel, Your Honor, but he's still going to be stuck on those.
Yeah, he's not going anywhere, so
Right.
we're not going to do that. We don't want you to waste your spiel.
Yes, ma'am.
Okay, well, are the felonies going to take care of all these 6 misdemeanors, Ms. Bettis?
Your Honor, if I may, prior to him picking up the 2 new cases, there was an offer that was on the table which did not include prison time. So I'm pretty confident that yes, they will dispose of the misdemeanor cases. I know this was, like I said, prior to him picking up the new cases. That, of course, is going to change now, given the fact that the state is looking at TDC time instead of probation. But they should be all disposed together.
Okay. Then for now, I guess we'll just wait for some of the felonies to get moving. If it looks like the felonies will not dispose of our misdemeanors, then we need to move ours, either by trial or plea. But since we're not doing trials right now, we'll just put everything on hold and revisit this case maybe in a couple of months and see where we are then.
Yes, Your Honor.
Okay.
Yes, Your Honor.
All right.
Thank you, Judge. Appreciate it.
All right. Have a good weekend, and we will see you all next time.
Thank you, Judge.
And
Be
Ms.
safe.
Bettis?
In 5 minutes.
Yes.